Hello, my name is Paul Dowling and I am a partner at Leigh Solicitors in London. I'm going to speak to you today about some legal developments that have been happening in the field of international corruption and whistleblowing in the UK. Just to start with a brief introduction to the international corruption and whistleblowing team here at Leigh. We are a medium-sized firm based in London, and we have a dedicated team of lawyers who act for individuals who have suffered some harm as a consequence of corruption in the workplace overseas. Our team has experience representing professionals across a range of sectors who've suffered adverse consequences to their careers, where they've become embroiled in some sort of unethical or unlawful practice through no fault of their own. And we're dedicated to ensuring access to justice for all and fighting for individuals who might not otherwise have the financial means to pursue their cases in court. So we've got decades of experience in litigation, and we act for individuals against some of the world's most powerful corporations. And there's just a list of our team members there. We also have expertise in a range of European languages, including English, Spanish, and French. So the case that I wanted to focus on today is a case called Rehan against Ernst & Young Global Limited and others. And this is a case in which we acted for the claimant, Mr. Rehan. Now, Mr. Rehan was a partner in EY, in Ernst & Young, and he worked in Dubai. And his role was, at least in relation to this particular engagement, was to conduct an assurance audit on a Dubai gold refiner called Kaloti. And the aim of that audit was basically to provide an independent view on whether Kaloti, the audit client, was satisfying certain standards in terms of its gold sourcing and its practices for ensuring that conflict gold and money laundering were not associated with its business. Kaloti was the most substantial gold refiner in Dubai and held the largest market share there. And our client, Mr. Rehan, was the engagement partner, so he was responsible for this audit. Now, a clean audit, so one that said that Kaloti's practices were sound, would have enabled Kaloti to be accredited with both the Dubai gold market regulator and also the international sort of quasi-regulator called the London Bullion Market Association, based in London. And following the audit, Kaloti was supposed to publish a compliance report endorsed by EY, which would set out the extent of its compliance with the applicable standards. So what did Mr. Rehan and his team find? Well, as they reviewed Kaloti's records, they uncovered that Kaloti was knowingly dealing in gold bullion which had been smuggled out of Morocco, coated in silver, for the purposes of deceiving the Moroccan authorities into believing that it was silver, thereby avoiding restrictions on the export of gold. Silver was then declared to be gold upon arrival in Dubai. Secondly, the second most serious issue that was encountered was that in 2012, which was the period that this audit covered, Kaloti had taken part in cash transactions in gold involving about $5.2 billion US. So both of those issues in particular gave rise to a reasonable suspicion that Calote was engaged in money laundering. And there were also serious issues regarding links with conflict minerals, which, as I said earlier, was one of the main purposes of the audit, including transactions with high-risk countries such as Sudan, DRC, and Iran. And for those who aren't familiar with the term conflict mineral, it basically means that it carries an increased risk. And due to where it's sourced from, the mineral carries an increased risk of being traded for the purposes of financing terrorist activity or organised crime. When Mr. Rehan confronted Calote with these findings, they were very angry about it. They insisted that the matter be referred to the Dubai regulator. And when that was done, the Dubai regulator, the DMCC, expressed concern that the findings against Calote would damage Dubai's image internationally and could adversely impact on the gold trade and Dubai economy. So the DMCC then started to put improper pressure on Mr. Rehan to reduce the cash and the Moroccan gold issues to what the judge later described as a vanishing point. So to remove reference to these transactions in the audit report. And, you know, one of the documents that came up in the disclosure in the case was the DMCC asking Mr. Rehan whether changing the review period of the audit would impact the rating positively. So Mr. Rehan was concerned about this, concerned about the pressure that he was coming under from the Dubai authorities, the Dubai regulator there, which is an arm of the Dubai government, and Calote. He escalated his concerns to the senior executives of EY in Europe, in London. What then transpired is that instead of supporting Mr. Rehan in resisting this pressure, what EY did was what the global office of EY did was to intervene and to take various steps that would facilitate the cover-up that was that Calote and the DMCC were keen to engineer. So EY, the proposals that they made were to amend the audit period mid-audit to avoid reporting the damaging findings, removing reference to Morocco in the audit report and changing the reference to coating of gold bars with silver to documentary irregularities, failing to indicate the scale of the cash transactions, which is obviously critical, and accepting accounts from Calote regarding the Moroccan gold that they knew to be untrue. And finally, endorsing the reports, the final reports, which were misleading because they avoided any attention being drawn to these damaging findings. Just struggling to move my page along. So what was the impact on the claimant? Well, he fled Dubai, then fearing for his safety. When he refused to cooperate with EY's strategy, he was subjected to improper pressure and intimidation by representatives of the defendants who threatened him with adverse career consequences, accused him of lacking professionalism. He was in fear of his safety because he had taken this stand against the Dubai authorities, and he was effectively alone in that and did not receive the institutional support of EY. He ultimately resigned and put the findings in the public domain. he went to the press and cooperated with an NGO to make these findings public. And after that, he basically became a public whistleblower. He was blacklisted in the sector. He was unable to obtain any further employment. And so from being a high-flying partner at EY, earning significant sums in a tax-free jurisdiction, he was now faced with unemployability. So coming on to the issues in the case then, Mr. Rehan was a partner in EY MENA, which was a UK company, but it wasn't a defendant in the case. We didn't sue EY MENA. The defendants were the UK-based governing entities of EY, on whose behalf Mr. Rehan's key interlocutors acted. So he didn't sue his contractual counterparty. He sued other entities, governing entities in the multinational network, who he said were actually responsible for the approach ultimately. So there was no employment claim there because he wasn't suing his employer. So the key issues that arose were, could a governing entity in a corporate network be liable for financial loss to an overseas partner of a member firm, despite there being no contractual relationship between the two? Secondly, if such liability could arise, what was the nature and scope of the duty that arose? And in particular, was it sufficient for the defendants to simply follow the rules set by the Dubai regulator? Because, as I said, they were seeking to make the rules up as they went along. And then then thirdly, could any such duty exist alongside the current statutory framework for whistleblowing in the UK? So there is a statutory framework that is designed to protect whistleblowers, and did this new duty cut across that statutory framework? And then finally, was Mr. Rehan's public disclosure a novus actus, i.e. did it interfere with the chain of causation such that it was in fact him who caused his own loss by going public rather than the defendants? This was an argument that was raised by EY at trial. So, what did the court find? Well, the court found that the EY defendants did owe Mr. Rehan a duty of care to take reasonable steps to prevent him from suffering loss of earnings by reason of their failure to perform the Coloti audit in an ethical and professional manner. The court found that the case did fall outside the scope of the statutory protections for whistleblowers here in the UK because the claimant was an overseas worker, and that regime does not cover overseas workers. So what the court said is that this new tortious duty that it created filled that gap in the existing statutory regime so as to cover overseas workers who suffered harm as a result of raising concerns of corruption in the way that Mr. Rehan did. The court found that the defendants, the EY defendants, had repeatedly breached the IFAC code, so this is the Code of Ethics for Professional Accountants, in their conduct of the audit. So the court used that code as a benchmark when assessing whether the conduct of the defendants was tortious. And the court rejected the defendant's argument that the claimant had caused his own loss by blowing the whistle and going public. They found that to be an inevitable and unavoidable consequence of what had happened, and that it was not a break in the chain of causation for the claimant to have taken that step. So what are the legal and any other ramifications of this case? What it certainly means is that it is now possible for somebody working outside of the UK to sue a UK-based organisation where that organisation has caused them harm, particularly economic harm, through unethical or unlawful behaviour. And I mean, just on that, there does need to be the requisite level of proximity between the parties. The court did refer to the interactions that Mr. Rehan had with representatives of the defendants, and the fact that that relationship of proximity was sufficient here for the duty to exist. But nevertheless, it did create this new duty of care not to embroil overseas workers in unethical conduct, and a duty to compensate them for economic loss that they may suffer as a result. Another important conclusion from the case is that domestic rules, so the UK rules of professional conduct, such as those set out in the IFAC code, would trump or supersede those of a foreign regulator. So despite the fact that EY consistently argued that there was no higher authority than the DMCC, the Dubai regulator, for this particular audit, the UK court said no. If UK companies are involved, they need to abide by their own applicable professional standards, and cannot circumvent those standards by relying on different standards that may be applied by a local regulator. So whistleblowers working in UK multinational organisations may be able to obtain substantial compensation where they are made to suffer economic harm as a result of raising issues of corruption. And just finally, these claims can be brought in the English High Court. So, as I said, outside the scope of the labour courts, the employment tribunal here in the UK, and that does bring some benefits in terms of funding. There are ways of funding these types of cases for whistleblowers who have lost their career, who are potentially impecunious. Lawyers may be able to represent them under conditional fee agreements, which means that such individuals would not need to fund legal costs up front. So that is a potential advantage in pursuing a claim of this sort. So that was all I was going to cover today. I hope you enjoyed the talk, and I'd be very happy if you want to email me to answer any questions that you may have about the presentation. Thank you very much.